Hello everyone, I'm GliorianeBlais. We are March 24th, 2025. I'm doing this live today, very important live, about because I wrote a request for revocation of the Chief Justice of Canada, Richard Wagner. I'm a Canadian citizen. I'm a French speaker, as you can hear. It's not my skill, English, even I did a lot of immersion in England, Canada and USA. Sorry for that. This request for the revocation of the Chief Justice of Canada, Richard Wagner, is very important and very unique. Very unique. It's the only one, on my knowledge, in the world. Why is my application, because I will do my request to the Supreme Court of Canada, is so urgent? Sorry, this is how I'm beginning this live. I'll state the reasons now. First, because we have just begun the very critical federal election campaign, the federal general election that may change Canada forever, in bad way or in a good way. Second, because if my request for revocation is to be given serious consideration in a parliamentary committee in the House of Commons, our elected representative must now demonstrate to Canadians their courage in the face of the most courageous discussion that urgently need to take place in Canada. Discussion, I'm talking. The most courageous discussion. Third, in order for you, the citizen, the people, to feel comfortable in making the approach, you will have to make to your ongoing MP and the candidate in your riding, you must have in your hands the official version of my request for revocation. The official version that will then have been officially filed with the Supreme Court of Canada. My request for revocation will be filled with my application for leave to appeal to the Supreme Court of Canada concerning the Quebec's Machiavellian Public Health Act. This is a procedure thing that I'm doing since 2020 about to declare unconstitutional the Public Health Act in Quebec province, but it's like that everywhere in Canada. It's these law permit the governments in Canada to abuse their power to submit people during COVID, the fake false pandemia and the false safe and effective vaccine. Then I repeat, this request for revocation will be filled with my application for leave to appeal to the Supreme Court of Canada concerning Quebec's Machiavellian Public Health Act. The deadline for the application for leave to appeal is April 8, 2025. Strategically, it's highly preferable that you, Canadian, get your hands on my application, on my request for revocation quickly, very quickly. To do this, I have to complete the payment on the legal assembly of the file. The legal assembly of the file, it's not a lawyer's job. It's not lawyers to do this. The legal works, it's done by me. the legal assembly of the file, it's a firm that puts together the files that hand over to them according to the rules of the Supreme Court and print it accordingly to the rule of the Supreme Court. All lawyers in Quebec province do business with such a firm at this judicial stage, at the Supreme Court stage. Their estimate of the firm do this legal assembly of the file. Their estimate of the bills is $5,527.11. $5,500. I'm used to with this firm. They are honest. They work very well. And if somebody criticizes, say, "Oh, it's so expensive," I understand. But I just want to inform you that when I was lawyer, I was used to use another firm, like to do the legal assembly of the file. And the other firm, when I talk about the judicial corruption, said to me for another reason that they cannot continue to work with me. Then what I'm saying is this firm accept to do this mandate for me, this legal assembly of my file, and I'm very, very happy of this. Then it's not time to criticize them. And I know that they try every time to, like if there is double document, they tell me they want that it costs as less as possible. They know that I asked donation for this. Then I've published this estimate $5,527 on my social networks. To date, I've paid $3,300. However, since I sacrificed everything to get here today, I have no financial cushion. And I wanted to say something that it was not writing in my note. You know, I just want to say, okay, I will explain to you before, after, but I was lawyer during 22 years. I'm not asking like returners as lawyer ask, like I know like in Quebec, one lawyer asked, like send an invoice for 300,000 returners to like an organization. And I'm not asking returners like that. I'm just asking to survive and pay the judicial fee. And last week, like when I was living in France, because I left Canada because my life was threatened. It's right on the brief of the application, the application to leave. I will read this later, but what I'm saying is I leave Canada in 1 year ago, in April 2024, like to save my life, and I flew to France, and by example, all the flight ticket for me, for the people, one person for my security accompanying. Was for me, with me for my security, for the flight, and because my life was threatened, and for my 2 children, they came 2 weeks after, and with 2 ladies, all the flight ticket, it's one of my friends pay with her credit card, and I give her back all of my furniture. What I'm saying is I use everything I have in my last penny to try to not ask you much, and it's not because I want to ask you, and when and for me, because I try to save my life, to continue the procedure I'm doing in Canada, it will be normal that the donation will pay the flight. in France, I was an asylum seeker. In France, I was no car. There was good bus services and trained, and I walk a lot. It was perfect for me. It was okay. I don't need like too much. And but since the France reject at the level of the National Court of Asylum, now it's another step. I will read to you later. Then since I'm in USA since November 2024, I live to a family. It doesn't charge nothing for the rent. Then I don't have to receive donation for my rent for now. But the place that I live, I need absolutely a car. Like there is no service. And then a person lend me one of his car. It's a used car. It's he pay the insurance and the immatriculation, but it's me has to pay if there is something's happened in the car. And last week the car like stopped to, like I was not able to start the car, and I was in the parking lot at the grocery in USA, and I had like to fix, and the brake was also finished. Then it's the owner of the car was around the last days. Then he take care to talk with the garage, and he knows the owner of the car know a lot about mechanic. Then it is sure that we didn't, like I didn't pay like extra, like over. And but I had Saturday to pay 1,500 to the garage to be able to have this car, and I need it. It's not because I want absolutely a car, it's I need it where I'm living. This I don't have to pay rent where I live, then it's really less expensive to continue to live where I live. But I need that car, that used car. Then now I have a little money left over to pay for my food and that for my children for this week. But it's not because I don't want to deposit this application for leave that it costs $5,527. I pay already because your donation. Thank you very much. 3,300. I have sacrificed everything to get where I am today, including, and it's a good thing because including where I am today, I am aware, including the 14th volume of evidence of judicial corruption. It's historical, this evidence I'm talking of judicial corruption, including the judicial corruption, the evidence of judicial corruption of the Supreme Court of Canada. This is very historical. What, like the evidence I have, like it's very solid. I live with family. As I said, I don't have to pay rent, but I have to feed myself and my children, obviously. Then I don't ask returners like 300,000. It's not about this. It's about to continue and be able to live not a normal life, but a life like survive. All my legal procedures are extremely solid. I was a lawyer for 22 years, as I said, and an expert in anti-corruption and health law. I was trained in anti-corruption by the International Bar Association from London, in UK, by experts from London, Paris, and Washington, D.C. I have a postgraduate degree in health law and policies. I'm an expert in civil liability and medical malpractice for victims. In March 2024, I launched the only class action in the world against elected officials, including Justin Trudeau, over the safe and effective vaccine lie for all Canadians, A very important hearing will take place, please take note of this, will take place at the Quebec City Courthouse shortly on take note of this, please. Monday, April 7, 2025, in Quebec City Courthouse, to which all Canadians are strongly invited. I am the only lawyer in the West to have been disbarred for speaking truthfully about judicial corruption and the dangerous experimental injection as early as spring 2021. Financially, I need more support. I cannot continue like that. As soon as I pay the total sum of $5,527.11, my request for removal from office against Chief Justice of Canada and Supreme Court of Canada Justice Richard Wagner will be filled. From that date, out of you, dear Canadian, will have in your hands my official request for revocation, which you will then have to hand to your ongoing MP and the candidate in your riding. You will have to, yes, because I can't do it alone. I cannot. Please consider a first donation or a new donation now. The information are on the live now. I will now read you my application for leave to appeal, which include my all-important request to revoke Richard Wagner. It's an English translation by Deep L. After I will read the article by the papers by Albertine lawyer, is a King's Counsel to Clayton Rice, and he wrote this article in June 2020, and I refer to his article for my request to revoke. Please now share this live in English to all of your contact in English, in Canada, everywhere. It's really important. All of the group that you are in English, to make sure that this information is shared, this request for donation, and also that the Canadians are already prepared to receive my request of revocation, that become their request of revocation and brings to the outgoing MP and the candidate in each of the riding in Canada for this federal election. Then my brief in my application for leave to appeal. Part 1. Concise statement of fact. As of March 2020, Canada, along with the rest of the Western world, has undergone a democratic drift, with a pandemic that turned out to be false because it was not actualized in the real fact, and with its false, safe and effective vaccine that turned out to be a dangerous experimental injection that constitute the worst crime against humanity that humanity has ever known. We are just seeing the tip of the iceberg. On this paragraph, I am referring to my application for permission to appeal to the Court of Appeal of Quebec. There is 4 volumes, and all of the information, the proof, the evidence, all of the arguments are in this. Then I didn't repeat for nothing. I just put what is new in the application. all will be in the application for leave in the request for revocation, Chief of Justice of Canada. Contrary to the constitutional principle judicial independence, both institutional and individual, whose objective is the impartiality of the judiciary, Chief Justice of Canada Richard Wagner has been involved in a political propaganda committee as described by Canadian lawyer and King's Counsel Clayton Rice. Since his involvement in this propaganda, I'm talking still the Chief Justice, since his involvement in this propaganda involving high treason against Canada and Canadians, Richard Wagner has maintained himself in the highest constitutional responsibility of the only constitutional counterpower, the judiciary. The fear, naivety, and unconsciousness of the people have ensured that no revelation has yet taken place in Canada. They speak the bankruptcy of the judiciary. The Supreme Court of Canada having been unwilling to contradict the criminal propaganda of which the Chief Justice was involved. In order for this appeal to be heard by with independence from a corrupt Chief Justice of Canada, it is important that Richard Wagner be removed from both the office of Chief Justice of Canada and Justice of the Supreme Court of Canada. While the Chief Justice of Canada was involved in a political propaganda committee involving high treason against Canada and Canadians, the plaintiff, a lawyer, myself, an anti-corruption expert, alert the Canadian public. Part 2, concise presentation of the issue in dispute. Question 1, should Richard Wagner be removed as Chief Justice of Canada and Justice of the Supreme Court of Canada? Question 2, should the present case finally be heard with judicial independence? Part 3, argument. Question 1. Should Richard Wagner be removed as Chief Justice of Canada and Justice of the Supreme Court of Canada? This is not only a request for Richard Wagner's recusal. This is also a request for his dismissal, for his revocation. As stipulated, because the translation was not perfect, for his revocation. As stipulated in Section 9 of the Supreme Court Act, this request for removal must be, for revocation, must be forwarded to the House of Commons, the Senate, and the current Governor General, since the Supreme Court of Canada has no jurisdiction in these matters. The plaintiff, myself, is an asylum seeker because of the persecution she has suffered she has suffered at the hands of the Canadian judiciary and her lack of protection by the police in Canada in the face of a death threat with writing by a lawyer in Canada. A lawyer, my lawyer in France, before the National Asylum Court of the French Republic, applied to the Council of State of the French Republic for legal aid. The application for asylum in the United States, among other things, that I'm seeking asylum because since 2020, I have been the victim of significant, violent, illegal, and abusive persecution by the Canadian justice system, including the Canada's highest court, the Supreme Court of Canada. It all started in 2020 when, as a lawyer, I received a fraudulent judgment at the end of a trial for my client, a very solid businessman who was the victim of the government corruption, abuse of power, against a crown corporation of the Quebec government in Canada, a lawsuit by my client for 35 million Canadian dollars. In March 2021, I filed an application for leave to appeal to the Supreme Court of Canada. In May 2024, Maître the lawyer Daniel Gagnon for the Quebec Bar, Barreau du Québec in French, Quebec Bar, logged the first lifetime disciplinary complaint against me. The lawyer Daniel Gagnon admitted on the oath on 2 occasions that he had never read a single page of the 14 volume of evidence except of my 20-page memoir, which are my allegation, ! On July 8, 2021, the Supreme Court of Canada failed in its constitutional responsibility by rejecting my client's application for leave to appeal. On March 14, 2022, the trial on the disciplinary complaint took place, at which the lawyer for the Quebec Bar, Daniel Gagnon, once again confessed to not having a single page of the 14 volume of evidence. The disciplinary board of the Quebec Bar found me guilty and disbarred me for 8 years, all illegally and abusively. Sorry, I was looking if there was an error. I have appealed to every court with the 14 volume of evidence in March from my March 2021 application for leave to appeal to the Supreme Court of Canada, and every court in Canada, every court, the Tribunal des Professions, Professional Court, the Superior Court, the Appeals Court of Quebec, every court has failed. Still on my disbarment, I filed a new application for leave to appeal with the Supreme Court of Canada on May 17, 2024, now containing 19 volumes, including the original 14 volume of evidence, which I have exceptionally also notified to the Governor General of Canada, Mary Simon, and the King of Canada and of the Commonwealth Kingdom, Charles III. On September 12, 2024, the Supreme Court of Canada again failed in its constitutional responsibility, and neither the Governor General of Canada nor the King publicly intervened in accordance with their constitutional responsibilities to protect Canada and its people from treason, because it is. On September 13, 2024, I signed my complaints against Canada to the United Nations Human Rights Council, received by registered mail on September 20, 2024. All the proof are through links, the Curium link in my brief, and it's proof in French. Is the point that is difficult. But the House of Commons will be able to ask the Supreme Court to receive a copy of the proof in English, because these 2 files at the Supreme Court should be translated in English, to be here in English. The file of 14 volume and the file of the 19 volume. It was an extract of my application to as asylum seeker Then I finish this extract. I continue my brief. Since the plaintiff myself is an asylum seeker under the protection of international refugee law, her address and telephone number must remain confidential. In view of this, only the Supreme Court of Canada can and must transmit this formal request for revocation to the House of Commons, the Senate, and the Governor General in office. Making sure to redact the address and telephone number are declared on the Form 23A filled with the request. This is the only way for the revocation request to be heard under the Canadian law and thus formally transmit in compliance with international refugee law. Question 2, number 2, should the present case, the case of unconstitutionality of the Machiavellian health public, just because it's in English for me, it's more difficult. This this case, it's about the unconstitutionality of the Quebec's Machiavellian Public Health Act, but in Canada we have all in province, each province a Public Health Act is the similar. It will make a precedent. Then it's not about just the Quebec province, it's about all Canada. They have Public Health Act, and it's this Public Health Act, this Machiavellian Public Health Act, permit the government to submit people, to terrorize people, to oppress people, and during the false pandemic and for the false COVID-19 vaccine. Then question 2, should the present case finally be heard finally, because there was another case to present to the Supreme Court of Canada, we know, and not the Supreme Court. Supreme Court refused all of them at the step of the application for leave to appeal. Then should the present case finally be heard with judicial independence? All Canadian constitutional principles support it. Otherwise, it won't, and it's not a joke, otherwise it won't just be Richard Wagner who has to be removed from office, but all the judges on the Supreme Court of Canada. Part 4, argument on cause. The plaintiff requests that cause follow the same course as the appeal. Part 5, order requested. The plaintiff, myself, requests that a formal application for the revocation of Richard Wagner be transmitted by the Supreme Court of Canada to the House of Commons, the Senate, and the sitting Governor General, with confirmation to the plaintiff, myself, of the actual transmissions of copy of our application leave to appeal, including redaction for the plaintiff address and telephone number. The plaintiff's request that her application for leave to appeal be granted about the unconstitutionality of the Public Health Act be granted, cause to follow. And at the part 6, there is an alphabetical table of source, and the legislation is the Supreme Court Act. And also there is the article of the lawyer from Alberta, and is also King Counsel Clayton Rice. He published in June 18, 2020. It's still on his website, and also an article in a newspaper in December 24, 2020, at when it was writing, and it's in French, I don't have the translation, that the demonstration anti-vax, a lawyer is in the bar of Quebec look at her like because I participated in a demonstration, as it's a constitutional right, I have to have a problem with the Bar of Quebec. This is the article in December 24, 2020, and why this article, this papers is in the 4 volume of including with my brief, the 4 volume that it was deposited at the Court of Appeal of Quebec. And this it showed that, because what I said, it's all people was involved in a demonstration, like peacefully, obviously, during the false pandemic, and for the false safe and effective vaccine, was everyone was a whistleblower. Everyone whistleblower to alert population, alert the public, and alert also the government. I was talking to the government during my life, and what I wrote, it's me, I was a whistleblower, a lawyer whistleblower, because we have big heart and we understand. I'm not saying people don't understand was not a big art. There is different reason why a person doesn't talk. Sometimes they just are naive, and the naivety, it's some things like brings it's against humanity. Finally, when you are naive, it's not good. Then now I will read the papers by the Albertan lawyer and King Counsel Clayton Rice. It's in English. Then I post on X and Facebook the information that when I informed that I was going to deposit, I'm going to deposit a request for revocation. And I add the picture of the Richard Wagner with some people call Santa Claus. Then on this post, there is a link, and if you click on the link, you the second link, the curium, it's the proof of it's all the documents I deposit at the Court of Appeal that I deposit again at the Supreme Court. But so there is another link, and if you click on it, you will find the article of the lawyer from Alberta in King Counsel. Then you will be able to read in English better than me, but I will read because I read in French. So then please share. I just remind you, please share to your contact, English speaker contact. Please share to all the English speaker group, please. It's important to be able to deposit this request for revocation. I need donation, and I don't have the caution the financial caution to do this, and also that everyone are prepared to, when I will have the official document, the official request of revocation, everyone in Canada are prepared, are ready to deposit this document to their ongoing MP and their candidate in their federal riding, and everywhere in Canada. It's very important. It's now. It's going now, not in 1 month. Then the title of the papers of Clayton Rice. Its date it's date June 18, 2020, just few weeks after the false pandemic began. The title is Chief Justice Wagner should resign from COVID-19 committee. Then I read this article, okay, this paper. The government of Canada has formed a self-described national leadership body called the Action Committee on Court Operation in response to COVID-19. The committee is so chaired by the Honorable David Lametti, Attorney General of Canada, and the Right Honorable Richard Wagner, Chief Justice of Canada. According to the federal government, the purpose of the committee is to develop national principles of the promotion of a harmonious approach to restoring Canadian court operation after the pandemic shutdown is lifted. 1. The mandate of the committee. The committee's mandate was described in a post to the Department of Justice website to include providing national guidance to support the restoration and stabilization of court operation, to facilitate information sharing and promote best practices, to focus primarily on the resumption of in-person judicial process, and to consider measures to modernize the system justice. The committee was initially composed of the Right Honourable Richard Wagner, Chief Justice of Canada, co-chair, Honourable David Lamity, Attorney General of Canada, co-chair, Honourable Jeffrey Morawetz, Chief Justice of the Ontario Superior Court of Justice, Honourable Mary Morrow, Chief Justice of the Court of Queen's Bench of Alberta, and now, I'm out of the text, now the Honourable Mary Morrow, she's now the last judge nominated at the Supreme Court of Canada. Now there is 9 judges at the Supreme Court of Canada. Richard Wagner is the Chief of Justice, and Mary Morrow, she was involved in this committee, was also she's also now, I think it's since 1 year, she's also now Justice Judge at the Supreme Court of Canada. Honourable Terry Matchett, Chief Judge of the Provincial Court of Alberta. Honourable David Eby, Attorney General of British Columbia. Nathalie G. Drouin, Deputy Attorney General of Canada. Tina Nemieszniewski, President of the Public Health Agency of Canada. René Thériault, Executive Legal Officer, Supreme Court of Canada. I think, I'm not sure, I should look before my English live. I think that René Thériault, she's member of the World Economic Forum, I think. René Thériault is a woman. Chief Justice Morawetz and Morrow are respective of the Canadian Judicial Council. Former Chief Judge Matchett was the past chair of the Canadian Council of Chief Judge. Just by the way, in the comment, I'm out of the text, that during the first pandemic, there was also the Governor General dismissed, and there was few weeks that there was no General Governor, and the Chief Justice Richard Wagner stay Chief of Justice of the Supreme Court of Canada, but also become Governor General of Canada. This is a nonsense in our democratic, upon the principle of the Constitution of Canada. This is nonsense, just by the way. On May 8, 2020, the Department of Justice announced that the committee held its first meeting. The announcement states that the committee works will focus on developing court-specific health and safety guidelines that can be adapted to the needs of individual court and community. While the court in Canada have remained open during the COVID-19 pandemic, court operations have been severely restricted as a result of public safety measures implemented by government. The mandate of the committee, I'm just writing the papers of the lawyer Clayton Rice King's Counsel. The mandate of the committee to ensure that the judiciary and court administrator have access to the best available information and practice will be crucial to public safety during the resumption of in-person service in the courthouse across the country. Second, the Chief of Justice in the public square. On June 13, 2020, in an article titled "Supreme Court Chief Justice Suggests Criminal Code Change to Cut into Court Backlogs," the journalist Olivia Stefanovich of CBC News report Chief Justice Wagner as stating that we are asking that the committee are asking that amendment to the criminal code be done, including change to the number of jurors and the rule of conduct in criminal case. This is not about unconstitutionality of the Public Health Act, but it's important for the revocation. All this information is important and even crucial. The comments made by the Chief Justice drew critical response from the criminal defense lawyer. Drew critical response from criminal defense lawyer. On June 18, 2020, in a follow-up article for CBC News titled "Some Lawyers Says Chief Justice Wagner crossed a line by suggesting criminal code change," the journalist Ms. Stefanovic report Toronto lawyer Adam Bonney as saying that legislative change to jury composition could be challenged under the Charter of Right and Freedom. The Supreme Court of Canada, as the highest court of appeal, will be the final arbiter of the constitutionality of such change. John Struthers, president of the Criminal Lawyers Association, characterized the Chief Justice's comments about politically charged legislative change as highly problematic. Very important. Third, what's at stake? Interrogation dot. It is deeply concerning for the Chief Justice of Canada to make public statement on a prospective legislative agenda. It is all the more concerning for the Chief Justice to actively inject in his office. Remember that the René Thériault, Executive Legal Officer, Supreme Court of Canada, is part of the committee, and maybe part of the W Economic Forum. Then I will just office. Okay, it is all the more concerning for the Chief Justice to actively inject his office into discussion about how that agenda may be shaped. It is a violation of the constitutional separation of power, undermines the independence of the judiciary, and erodes Canadian democracy. It is the function of the judiciary to rule on the validity of legislation after enactment, not participate in the policy debate before enactment. The legislative process is inherently political, and the judiciary has no place in the political arena. This is like principle very known for constitutional lawyer. I wrote a procedure in federal court. I know this principle. It's really like the basic for constitutional lawyer. Sorry for my English. The attorney, as I said, you may go to read the document. The Attorney General of Canada may consult the judiciary on matters affecting the administration of the court. There is nothing specific in the committee's terms of reference that engage the judiciary in the development of legislative policy in respective of transparency. If the federal government has concern about the validity of any legislative action, it may take. The proper recourse to the court would be a reference question brought by the governor in council under the section 53 of the Supreme Court Act. The conduct of the Chief Justice has compromised the right of the governor in council under the statute. Litigation may be initiated in criminal case by a constitutional challenge under the charter and by originating pleadings on the provincial rules of court. The legal tests of necessity and proportionality are on the origin under Section 11D of the Charter. Every Canadian has the right to an independent and impartial court, free from political influence in the application of these analytical tools by the judiciary to determine the overbreadth of government action. The Chief Justice has compromised the fair trial interest for all Canadians as beneficiaries of the right to an independent and impartial court, a right that it is intrinsic to the rule of law. The rule of law, what is it? I'm just out of the text. The rule of law is when a country is follow the principle of democracy, and for that we have to follow the Constitution in Canada. This is the basic. And upon the Supreme Court of Canada, the Constitution is the supreme law in Canada. Then if the court doesn't follow the Constitution of Canada, that doesn't follow the rule of law. We are not in a country with the rule of law then. Chief Justice Wagner will do well to bear in mind the majority opinion of his court in Makin versus New Brunswick 2002 1 SCR 405, where the late Justice Charles Gontier held that a court must not only be truly independent, but it must also be reasonably seen to be independent. In order for, it's a citation, in order for, I quote, Clayton Rice, the lawyer, quote, the Supreme Court, in order for independence in the constitutional sense to exist, he said at paragraph 38, a reasonable and well-informed person should not only conclude that there is independence in fact, but also find that the conditions are present to provide a reasonable perception of independence. Only objective legal guarantee are capable of meeting this double requirement. End of the quote. The station. The independence of a particular court has a dual dimension, an individual dimension and an institutional dimension. Individual dimension relate to the adjudicative function of judge, whereas institutional independence relates to the status of the judiciary as an institution that is the guardian of the Constitution of Canada. Although both dimensions are engaged by this controversy, because it is a controversy, it is the institutional dimension that is I'm reading the text of Clayton Rice. It's the constitutional dimension that is my primary concern here. As Justice Gontier went on to say in Mankin at paragraph 39, the judiciary as guardian of the Constitution, I quote, reflect a profound commitment to the constitutional theory of the separation of powers. End of citation. See also R versus Valente, 1985, 2 SCR 673 per Eldine Justice at paragraph 20. That is the point. The commitment to the separation of power is diminished when the judiciary invade the domain of the executive and legislative branches and publicly engage in a policy debate about what a legislative agenda might be. In the Federalist, May 28, 1788, Alexander Hamilton, one of the founding fathers of the Constitution of the United States, put in this way. I quote, "The executive not only dispense the honor, but holds the sword of the community. The legislature not only command the purse, but prescribe the rule by which the duty and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the straight or of the wealth of the society. It can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment." And it's from in BuyMeACoffee edition, Debate on the Constitution, Part 2, the Library of America, 1993, at, I think it's a page 468. Fourth conclusion of the paper of Clayton Rice, lawyer in Canada, Canadian lawyer and King's Counsel. If the report comment of the Chief Justice Wagner are accurate, he should resign from the COVID-19 committee in order to protect the right of the governor and council, the right of every Canadian to a fair trial, and the integrity of the Supreme Court of Canada as the guardian of the Constitution. Without open independence and the communication that independent to the public, the Canadian judiciary cannot claim legitimacy. Wow. Then this is the end of my live. Please share this live to English speaker, your contact, out of your contact, even it's out of Canada and out of your English group. And thank you very much for to listen this live.